The community of Cedar Ridge Crossing wasn't merely a collection of houses, it was a meticulously curated statement. It presented itself to the world, and more importantly, to its residents, as an enclave of orderly elegance, a bulwark against the perceived chaos of the outside world. Immaculate landscaping, dictated by a surprisingly detailed seasonal planting guide, lined the wide, gently curving streets. Houses, adhering strictly to a palette of HOA-approved muted earth tones, stood in quiet, uniform rows. The silence, often profound, was typically punctuated only by the rhythmic hiss, tick-tick, of automated sprinkler systems activating with programmed precision, or the distant, reassuring hum of a professionally maintained lawnmower, sculpting yet another perfect lawn. In Cedar Ridge, rules were not gentle suggestions, they were scripture, codified in a binder thick enough to serve as a doorstop, distributed annually, and, this was the crucial point, enforced with the unwavering, almost zealous vigilance of the Homeowners Association president, Patricia Sterling. Patricia Sterling was a woman seemingly forged from steel and starch. Her sharp business suits, even on sweltering summer days, looked permanently pressed, her posture rigidly erect. Her dark hair was always pulled back into a severe, tight bun, a style that permitted no errant strand to escape its disciplined confinement. Much like her vision for the community itself, to Patricia, Cedar Ridge wasn't just the place she lived, it was her personal fiefdom, a reflection of her own exacting standards. She wielded the HOA bylaws not as guidelines for harmonious living, but as a scepter of absolute authority. Her patrols of the pristine sidewalks were legendary, conducted with brisk, purposeful strides, her ever-present digital tablet held aloft like a shield. A critical eye scanned for violations. A garbage can left out 10 minutes past the deadline. A patch of lawn exhibiting insufficient greenness. Holiday decorations lingering a day too long. Each perceived infraction was documented with swift, decisive taps on the screen, time-stamped and categorized for later action. Her leadership style eschewed collaboration in favor of pronouncements, fueled by an unshakable, almost religious belief in her own superior judgment and a thinly veiled, simmering disdain for anything or anyone that dared deviate from her rigidly narrow definition of suburban perfection. Beneath the strained surface-level politeness, a genuine current of apprehension flowed through the community. Neighbors exchanged nervous jokes about needing HOA approval for the color of their petunias, but no one truly laughed. Patricia Sterling, or President Patty, as some dared to call her with a forced, brittle brightness when safely out of earshot, was unequivocally not someone to be crossed. Recently, a new crusade had captured Patricia's formidable attention, a perceived blight threatening the carefully constructed aesthetic harmony of Cedar Ridge animals. While the existing bylaws, drafted long before her ascent to power, permitted conventional pets under certain stringent size and breed restrictions, no breeds deemed aggressive, nothing over 40 pounds. Patricia harbored a particular, visceral animosity towards what she contemptuously termed loophole animals, emotional support animals, or ESAs. In her uncompromising view, these weren't necessary therapeutic aids for genuine mental or emotional well-being, but rather flimsy excuses, blatant attempts by residents to circumvent the established pet rules. She envisioned ESAs as Trojan horses, smuggling potentially messy, noisy, or, worst of all, unpredictable creatures into a meticulously controlled environment. Her complaints became a recurring theme at HOA board meetings, delivered with the force of prosecuting arguments. How can we possibly differentiate a therapy dog from a common pet? She'd demand, her voice sharp. There's no visible certification. No uniform. It's chaos. She painted lurid pictures of untrained animals menacing children, digging up prize-winning rose bushes, and lowering property values with their very presence. If we acknowledge one supposed ESA without rigorous proof, she warned darkly, leaning forward over the polished boardroom table. We open the floodgates. Every resident wanting a dog they can't otherwise have will suddenly develop anxiety and find some online doctor to sign a form. It undermines everything we stand for. Quiet opposition flickered briefly. One board member, a mild-mannered accountant named David Chen, cautiously mentioned something about federal regulations and disability rights, citing an article he'd read. Another, Sarah Jenkins, a retired nurse, tentatively suggested consulting the HOA's attorney regarding potential legal exposure. Patricia steamrolled their concerns with imperious disdain. Federal regulations are guidelines. David, often misinterpreted, she declared, waving a dismissive hand. And Sarah, legal fees are an unnecessary expense when the matter is clear-cut. Our community rules, duly adopted by this board, are paramount within the boundaries of Cedar Ridge. We have the right, indeed the obligation, to set our own standards. Her forceful personality, combined with the other board members' reluctance to engage in direct confrontation, carried the day. Dissent withered under her glare. The culmination of her relentless campaign arrived not with a bang, but with a chillingly stark email and a prominently posted notice on the corkboard in the community clubhouse, right next to the approved paint color chart. The subject line read, Addendum to Community Rules and Regulations, Animal Policy Update, effective immediately. The language within was unambiguous, brutal in its simplicity. Cedar Ridge Crossing would no longer permit any emotional support animals within the community boundaries, regardless of documentation, prescription, or stated need. The addendum specifically stated that so-called ESA letters obtained online or from general practitioners without specialized psychiatric evaluation will not be considered valid. Existing ESAs were granted a stark 60-day grace period to be permanently rehomed outside of Cedar Ridge. Failure to comply would result in immediate, escalating fines, starting at a punitive $500 for the first documented offense, doubling with each subsequent citing. The justifications cited were couched in familiar Patricia-isms, maintaining aesthetic harmony, addressing sanitary concerns, and preserving the unique tranquil nature of our community. Pointedly, crucially, the document made absolutely no reference to the Fair Housing Act, FHA, the Americans with Disabilities Act, ADA, or the established rights of individuals with disabilities. In Patricia Sterling's carefully constructed reality, the HOA's authority within Cedar Ridge was absolute, trumping inconvenient federal laws which she viewed as mere suggestions, easily overridden by the board's, her, decree. The announcement landed like a thrown stone in the placid pool of Cedar Ridge life. Ripples of fear, disbelief, and quiet fury spread through the community. Whispered conversations, laced with anxiety, took place over meticulously trimmed hedges and during hushed evening dog walks for the owners of permitted pets. Sarah Jenkins, the retired nurse from the board, felt a cold dread. She knew several neighbors relied heavily on their animals. David Chen, the accountant, worried about the inevitable financial fallout if the HOA was sued. One resident particularly affected was Mark Jensen, a young Army veteran who lived quietly on Maple Court. He battled severe PTSD, a remnant of 2 difficult tours overseas. His therapist had formally prescribed Bailey, a gentle, goofy Labrador retriever, as an ESA. Bailey wasn't just a pet. She was trained to recognize the onset of Mark's panic attacks, providing grounding pressure and a calming presence. Mark, clutching Bailey's official prescription letter and VA documentation, attempted to speak rationally with Patricia Sterling at the clubhouse during her posted office hours. He explained Bailey's crucial role in his daily stability, his voice trembling slightly. Patricia, barely looking up from her tablet, where she was reviewing landscape violation photos, cut him off curtly before he could finish. "Mr. Jensen, the rules are the rules," she stated, her voice devoid of empathy, her eyes cold and dismissive. "Cedar Ridge has standards to maintain. If your medical condition requires the presence of an animal, perhaps this exclusive community isn't the appropriate environment for you." The implication hung heavy in the air. Mark left the encounter feeling shaken, unheard, and utterly defeated, the door clicking shut behind him with chilling finality. Among the other residents whose lives were thrown into turmoil was Judge Arthur Pendleton, retired, a man whose bearing exuded quiet dignity and whose speech was always measured. Judge Pendleton had served with distinction for 25 years on the federal bench. He had presided over complex, often contentious cases involving everything from corporate malfeasance to civil rights disputes, earning a reputation for wisdom, deep legal knowledge, and unwavering impartiality. He and his beloved wife, Martha, had moved to Cedar Ridge upon his retirement, seeking the advertised tranquility after decades consumed by the demanding pressures of the judiciary. Martha's unexpected passing 2 years prior had shattered that tranquility, leaving the judge adrift in a sea of crushing silence and profound loneliness. The large, beautifully appointed house suddenly felt cavernous, empty. His physician, noting alarming signs of deep depression and persistent anxiety during a routine checkup, had formally prescribed an emotional support animal as part of his treatment plan. Enter Winston. Winston was a gentle, aging golden retriever whose soulful brown eyes seemed to hold ancient wisdom and whose tail, despite his advancing years, seemed perpetually engaged in a slow, happy wag. Winston wore no special vest or harness. The law didn't require it for ESAs in housing, but his presence was transformative. He became the judge's constant, warm, breathing companion, a furry anchor in the lonely quiet. He offered non-judgmental comfort during long evenings, his soft nudges a reminder of life continuing. More practically, Winston provided a crucial reason for the judge to leave the house each day for necessary walks, fostering brief, quiet interactions with neighbors he might otherwise avoid. Gentle re-entry into the small rhythms of community life. Winston was impeccably behaved, never barking unnecessarily, always kept on a leash during their slow ambles. The very picture of a calm, dignified companion. He was, in the truest sense, therapeutic. Judge Pendleton read Patricia Sterling's emailed addendum later that day, sitting in his study, Winston lying peacefully at his feet. He read it once, then again, a growing sense of disbelief washing over him. This wasn't just unreasonable neighborhood policy, this was breathtakingly illegal. Disbelief quickly hardened into a familiar, cold clarity, the clarity of legal analysis, of precedent, of statutory interpretation. He knew the law. He hadn't just read about the Fair Housing Act. He had adjudicated cases involving its intricate provisions. He understood its scope, its purpose, its specific protections afforded to individuals with disabilities. Protections that explicitly included the right to reasonable accommodations in housing, including the allowance of verified assistance animals like ESAs, even in communities with strict no-pet policies. Patricia Sterling wasn't just being unreasonable or overzealous, she was, with staggering arrogance, flagrantly violating federal law. A few days later, the afternoon sun filtering warmly through the leaves of the mature oak trees lining Chestnut Lane. Judge Pendleton was taking Winston for his leisurely constitutional. It was a slow, meditative ritual, the familiar feel of the leash in his hand, Winston's steady pace beside him, the quiet murmur of the neighborhood. As they ambled past Patricia Sterling's immaculate residence, its lawn perhaps the most perfect in all of Cedar Ridge, its windows reflecting the sky like emotionless eyes, the imposing front door opened abruptly. Patricia Sterling emerged, tablet held prominently, her expression a thundercloud of displeasure. She had clearly been watching for them. "Judge Pendleton," she called out, her voice sharp, cutting through the afternoon quiet, stopping him in his tracks. Winston, ever the gentleman, sat patiently by the judge's side, looking up at Patricia with mild curiosity. "Miss Sterling," the judge replied, his tone perfectly even, betraying none of the weariness he felt. "I trust," she began, taking a step towards them onto the sidewalk, tapping her tablet screen with a manicured finger for emphasis, "that you received the official notice regarding the new community regulations on animals." "I received the email communication." "Yes," Judge Pendleton confirmed calmly. "Then you are fully aware," Patricia continued, her voice rising slightly, taking on a lecturing tone, "that this animal," she gestured dismissively towards the quietly sitting Winston, her lip curling almost imperceptibly, "is no longer permitted within the boundaries of Cedar Ridge Crossing. This serves as your first official warning. Documented." She tapped the tablet again. "Continued violation of this clearly stated rule will result in the levying of fines, commencing immediately upon the expiration of the 60-day grace period, as outlined in the addendum." Judge Pendleton met her hard gaze directly, his own eyes steady. "Miss Sterling," he began, his voice remaining calm but taking on a subtle weight, a resonance that hinted at decades spent commanding a courtroom. "Winston is not merely a pet, as you seem determined to classify him. He is a documented emotional support animal, prescribed by my treating physician for a recognized disability resulting from," he paused, choosing his words carefully, "a significant personal loss. Under the explicit provisions of the Federal Fair Housing Act, specifically Section 504, the HOA is legally required to provide reasonable accommodation for residents with disabilities. Allowing verified ESAs, such as Winston, falls squarely under the definition of reasonable accommodation." Patricia let out a short, sharp bark of incredulous laughter. "Oh, that FHA nonsense," she scoffed, rolling her eyes dramatically. "Judge, with all due respect to your past position, that federal overreach hardly supersedes our community's private rules and regulations. We are a private development, governed by our own covenants. The board has voted. The decision is final." She waved a hand dismissively. "And this documentation you speak of, please. Everyone knows those letters are easily obtained online these days for $50. They mean absolutely nothing here. Cedar Ridge has standards to uphold. The animal," she finished, her voice hardening, "needs to go. Miss Sterling," the judge repeated, his patience wearing thin but his composure holding firm. "Allow me to be unequivocally clear. The Fair Housing Act absolutely applies to Cedar Ridge Crossing, regardless of its private status. That is settled law. It explicitly prohibits discrimination in housing based on disability. Denying a necessary and requested reasonable accommodation, such as a documented ESA, constitutes such discrimination." He held her gaze. "Your newly enacted rule is, therefore, unlawful on its face." "Unlawful according to whom?" "You," Patricia retorted, bristling at the challenge, her arrogance apparently blinding her to the irony of lecturing a retired federal judge on federal law. "I am the president of this homeowners association, duly elected, and I am charged with enforcing the rules adopted by the board for the betterment of this entire community. Consider this your final, official warning before financial penalties commence. You have 60 days." She straightened her shoulders, radiating smug certainty. "Good day, Judge." Without waiting for a reply, she turned sharply on her heel and marched back into her perfectly maintained house, the door closing behind her with an air of finality. Judge Pendleton stood motionless for a long moment on the sun-dappled sidewalk, the sharp click of Patricia's closing door echoing in the quiet air. He looked down at Winston, who nudged his hand gently with his nose, sensing his master's disquiet. The judge sighed, a deep, weary exhalation that carried the weight of unexpected conflict. He had envisioned a quiet retirement filled with books, gardening, and peaceful walks. Instead, it seemed, the fight for fundamental rights, a fight he thought he'd left behind in the courtroom, had followed him home to this manicured suburban enclave. He knew instantly that arguing further with Patricia Sterling would be utterly futile. Her willful ignorance of the law was surpassed only by her unshakable conviction in her own supreme authority. Appealing through the HOA's internal grievance process, a process she clearly controlled and manipulated, would be a pointless exercise in frustration. He turned, resuming his walk with Winston, his mind already shifting, the familiar gears of legal strategy beginning to turn. He wouldn't play her game. He would bypass the HOA entirely and go straight to the appropriate federal authority. The following morning, Judge Pendleton did not waste time composing a carefully worded letter of appeal to the Cedar Ridge HOA board. He knew such an effort would land on Patricia Sterling's desk and be summarily dismissed. Instead, he sat down at his own desk, switched on his computer, and began to meticulously draft a formal housing discrimination complaint. He addressed it directly to the regional office of the U.S. Department of Housing and Urban Development HUD, with the precision and clarity honed by decades on the bench. He detailed the Cedar Ridge HOA's newly enacted rule explicitly banning emotional support animals. Patricia Sterling's role as HOA president in championing and enforcing this rule, her direct verbal confrontation with him, and her explicit refusal to acknowledge his rights under the Fair Housing Act. He clearly articulated how this constituted discrimination based on his documented disability. He attached digital copies of the official letter from his physician prescribing Winston as an ESA, a brief, dignified explanation of the animal's necessity for his emotional well-being following his wife's death, and a copy of the HOA's offending email addendum. He knew the process intimately. HUD would investigate the complaint, determine if reasonable cause existed to believe discrimination occurred, and if so, attempt conciliation. Failing that, enforcement actions would follow. He clicked send, the digital submission feeling both anticlimactic and deeply significant. Weeks slipped by. The rhythms of Cedar Ridge continued. The lawn stayed green. The sprinklers hissed on schedule. Judge Pendleton continued his daily walks with Winston, maintaining a polite, distant nod when his path inevitably crossed with Patricia Sterling's during her own patrolling rounds. She, in turn, seemed to regard him with a mixture of smug impatience and disdain, perhaps assuming the old judge, as she likely thought of him, was bluffing or would eventually cave under the threat of fines, pack his bags, and leave her perfect community unsullied. She clearly underestimated Arthur Pendleton. Then, the official envelope arrived. Thick, bearing the seal of the Point US Department of Housing and Urban Development. It landed not in Judge Pendleton's mailbox, but at the HOA's small, part-time management office located near the community pool. It was addressed formally to the Cedar Ridge Crossing Board of Directors, with appointed attention, Miss Patricia Sterling, President. Inside was a formal notification. HUD had received and accepted for investigation the housing discrimination complaint filed by resident Arthur Pendleton Case Sharp. The letter detailed the allegations: violation of the Fair Housing Act through the implementation of a discriminatory policy banning assistance animals, and the refusal to grant a reasonable accommodation. It stated that a federal investigation was now officially underway into the policies and practices of the Cedar Ridge Crossing HOA regarding assistance animals, and requested cooperation, including the provision of relevant documents and records. The HOA's part-time manager, Brenda, a perpetually nervous woman who tried desperately to stay out of Patricia's line of fire, delivered the letter to Patricia with trembling hands during her next visit to the office. Patricia's reaction was immediate and predictable. After a cursory scan, she tossed the letter contemptuously onto the desk. "Bureaucratic nonsense," she declared, her voice sharp with annoyance. "Overreach. He's just trying to intimidate us, throwing his weight around because he used to wear a robe." She convened a hasty, informal phone call with the other, mostly compliant, board members later that day. "He thinks flashing his old title will make us back down," she assured them confidently. "We stand by our rules. They were adopted for the good of the entire community. Let HUD investigate all they want. They'll find we are perfectly within our rights as a private association to maintain community standards and protect property values." Against Brenda's timid suggestion to forward the letter to the HOA's retained attorney, Patricia scoffed. "Absolutely not. That's an unnecessary expense. Brenda, draft a response. Be firm. Reiterate our position. We will not be bullied by federal agencies or disgruntled residents." She essentially instructed Brenda to draft a defiant reply, daring HUD to challenge the HOA's autonomy. The HUD investigation, however, proceeded with quiet, methodical professionalism. Unperturbed by Patricia's bluster, investigators interviewed Judge Pendleton at length, respectfully reviewing his documentation and listening intently to his account. They contacted and interviewed other residents, including Mark Jensen, the veteran Patricia had so callously dismissed, whose testimony powerfully corroborated a pattern of disregard for residents' rights. They requested and received copies of the HOA's governing documents, the specific ESA ban addendum, minutes from the board meetings where the ban was discussed, and voted upon minutes which revealed Patricia's dominance and the quashing of dissenting concerns, and records of Patricia's interaction with Judge Pendleton. The evidence mounted rapidly, painting an increasingly clear picture not just of an illegal policy, but of discriminatory intent actively driven and enforced by the HOA president herself. HUD's subsequent attempt at formal conciliation, a standard step involving proposing a settlement where the HOA would rescind the rule, apologize, and undergo training, was met with outright refusal from Patricia, representing the board without legal counsel present, against HUD's recommendation. She dug in her heels, refusing to acknowledge any wrongdoing, refusing to consider rescinding the perfectly valid rule. "We will not negotiate our community standards," she stated flatly to the HUD conciliator over a tense conference call. Consequently, the bureaucratic wheels turned. HUD, finding its conciliation efforts futile in the face of such intransigence, issued a formal determination of reasonable cause and a charge of discrimination against the Cedar Ridge Crossing HOA. This finding concluded that reasonable cause existed to believe that discriminatory housing practices had indeed occurred. Typically, such cases might proceed to an administrative law judge. However, given the blatant nature of the violation, the clear evidence of discriminatory intent, Judge Pendleton's own background, and the HOA's defiant refusal to conciliate, the case was escalated. It was referred to the U.S. Department of Justice for litigation in federal court. Federal attorneys reviewed the file and swiftly agreed to take up the case, filing a civil lawsuit against the Cedar Ridge Crossing Homeowners Association, Incorporated, and, crucially, they took the significant step of naming Patricia Sterling personally as a co-defendant, citing her direct, instrumental role in creating, implementing, and enforcing the discriminatory policy despite having reason to know it was potentially unlawful. The day a U.S. Marshal formally served Patricia Sterling with the federal lawsuit papers, delivering the thick packet of legal documents to her doorstep while she was pruning her already perfect rose bushes, marked the beginning of the end of her autocratic reign. The imposing legal caption, United States of America v. Cedar Ridge Crossing Homeowners Association, Incorporated, and Patricia Sterling, and the detailed allegations within, finally seemed to penetrate her formidable armor of arrogance, the reality of facing federal charges, the potential for crippling fines levied not just against the HOA, but against her. The prospect of depositions, discovery, public testimony, it hit her with the force of a physical blow. Panic, cold and sharp, began to claw its way through her certainty. Belatedly, frantically, she contacted the HOA's attorney, Michael Chen, David Chen's cousin, ironically, who listened in stunned silence as Patricia recounted the saga, minimizing her own role and blaming Judge Pendleton's litigiousness. Michael was aghast, not just at the flagrant illegality of the ESA ban, but at Patricia's reckless decision to ignore the HUD investigation and refuse legal counsel during conciliation. "Patricia," he said, his voice strained, "do you have any idea how serious this is?" The federal court proceedings became a spectacle of slow-motion public humiliation for Patricia Sterling. Dressed each day in her severe, impeccable business attire, she sat rigidly at the defendant's table beside the increasingly stressed HOA attorney, attempting to project an aura of confidence that visibly crumbled with each passing hour. The cavernous, wood-paneled courtroom, the stern gaze of the presiding federal judge, who regarded Patricia with a distinct lack of warmth. The meticulous presentation of evidence by the sharp, focused assistant U.S. attorney assigned to the case, it was a world away from the compliant echo chamber of her HOA board meetings. When Judge Arthur Pendleton was called as the government's primary witness, a hush fell over the courtroom. He took the stand with quiet dignity, his steps measured, his voice calm and clear as he responded to the AUSA's questions. He spoke not with anger or vindictiveness, but with the quiet authority of someone deeply versed in the law and personally affected by its violation. He methodically explained the legal framework of the Fair Housing Act, the established definition of disability under federal law, the recognized role of emotional support animals as a form of reasonable accommodation, and then detailed Patricia Sterling's explicit refusal to comply with the law during their sidewalk confrontation. He described, simply and movingly, the profound comfort and stability Winston provided him in the wake of his wife's death, characterizing the dog not as a mere pet enjoyed for pleasure, but as an essential element prescribed by his doctor for managing a diagnosed condition impacting his daily life. His testimony was precise, credible, and devastatingly effective. He felt his own heart rate quicken slightly, not from nerves, but from the resurfacing pain of that loneliness. the quiet desperation Winston had helped alleviate. A desperation Patricia had threatened to reinstate through sheer prejudice. Across the courtroom, Sarah Jenkins, the retired nurse, watched Judge Pendleton testify, tears welling in her eyes. She remembered Mark Jensen's defeated face after his encounter with Patricia. She thought of her own neighbor down the street, Miss Smith, a young single mother whose anxious young daughter had bonded deeply with a small ESA cat prescribed by her child psychologist. Miss Smith had confessed her terror to Sarah after the ban was announced. Terrified of losing the cat and facing Patricia's fines, seeing Judge Pendleton stand up, not just for himself, but implicitly for all of them, filled Sarah with immense gratitude and a surge of hope. Patricia Sterling's turn on the witness stand was the trial's dramatic low point for the defense. Her carefully rehearsed attempts to justify her actions as necessary measures to uphold community standards and protect property values sounded hollow, petty, and overtly discriminatory when juxtaposed against the weight of federal anti-discrimination law explained so clearly by Judge Pendleton. Under sharp, relentless cross-examination by the AUSA, her composure fractured. Her voice grew shrill, her answers defensive and evasive. Her ignorance of the Fair Housing Act's specific mandates was laid bare for the court to see. "I am not an attorney," she snapped at one point. "I am a concerned homeowner trying to run a community." The AUSA calmly presented emails and board meeting minutes entered into evidence, highlighting passages where Patricia had actively dismissed legal concerns raised by David Chen and Sarah Jenkins, where she had pushed the vote through with sheer force of will, where she had referred to ESA documentation as meaningless pieces of paper. Her carefully constructed facade of competent leadership crumbled into dust, revealing the petty tyranny beneath. Sweat beaded on her upper lip despite the courtroom's cool air. Sensing the case slipping away catastrophically, Patricia made one final, desperate gamble during a recess, a move born of panic and vindictiveness. Working late into the night with a reluctant Brenda pressured into assisting, she attempted to fabricate evidence. They concocted a series of anonymous neighbor complaints about Winston, alleging excessive barking, which Winston never did, claiming he'd been seen off-leash untrue, even vaguely suggesting he'd acted aggressively towards a child, a complete fabrication. Patricia intended to have the HOA attorney introduce these belatedly discovered complaints to try and paint Winston as a nuisance, thereby justifying the ban after the fact and attempting to damage Judge Pendleton's credibility. The desperate ploy backfired spectacularly. When the HOA attorney hesitantly attempted to introduce the poorly drafted, suspiciously timed complaints, the AUSA objected immediately. Under brief questioning from the judge, Brenda, terrified of perjuring herself in federal court, broke down and admitted the complaints were fabricated at Patricia's direction just days earlier. The revelation sent a wave of shock through the courtroom. Patricia's face flushed crimson, then drained to a ghastly pale. Her last shred of credibility evaporated. The HOA attorney looked utterly mortified, quickly withdrawing the fabricated evidence and practically shrinking into his chair. Patricia had not only failed to discredit the judge, she had potentially exposed herself and Brenda to charges of perjury and obstruction of justice. The ruling, when it came a few days later, was swift, decisive, and utterly unequivocal. The federal judge, reading from a prepared statement, found comprehensively in favor of Judge Pendleton and the United States government. The Cedar Ridge Crossing HOA's blanket ban on emotional support animals was declared illegal, discriminatory, and wholly unenforceable, a direct and flagrant violation of the Fair Housing Act. The court issued a permanent injunction, ordering the HOA to immediately rescind the illegal rule. revise all governing documents and policies to explicitly comply with federal FHA regulations regarding assistance animals, both service animals and ESAs, and, significantly, mandated comprehensive FHA compliance training for all current and future board members, officers, and any management staff, to be conducted by a HUD-approved provider at the HOA's expense. Then came the hammer blow of penalties, citing the HOA's blatant disregard for federal law, its refusal to engage in good faith conciliation, and the clear evidence of discriminatory intent. The judge levied substantial civil penalties against the Cedar Ridge Crossing Homeowners Association, fines running into the tens of thousands of dollars, an amount guaranteed to create a significant financial crisis for the community association and its members. But the judge didn't stop there. Pointedly citing Patricia Sterling's primary, driving role in initiating, championing, enacting, and defiantly enforcing the illegal policy, her deliberate disregard for warnings, and her last-minute attempt to introduce fabricated evidence, the court took the extraordinary step of finding her personally liable for a substantial portion of those monetary damages. Her personal assets were now officially on the line to satisfy the federal judgment. The verdict reverberated far beyond the courtroom walls, making local and even some national news headlines. News segments and online articles portrayed Patricia Sterling as the epitome of the out-of-control, power-mad HOA president, a cautionary tale of arrogance leading directly to a costly downfall. Disability rights organizations across the country celebrated the case as a significant victory, highlighting the enforceability of the Fair Housing Act against resistant HOAs and the crucial protection it offers for individuals relying on assistance animals. Back within the manicured confines of Cedar Ridge Crossing, the reaction was a volatile mixture of shock, simmering anger, and profound relief. Residents were furious about the massive fines levied against the HOA, knowing that special assessments or significant dues increases were now inevitable. The blame fell squarely, and almost universally, on Patricia Sterling. The HOA board, facing immense pressure from outraged residents, potential derivative lawsuits, and the harsh reality of the judgment, convened a tense, emergency executive session. With minimal debate, Patricia Sterling was summarily removed from her position as president and stripped of all board duties and committee assignments. Effective immediately, her reign was officially, ignominiously over. In the aftermath, Cedar Ridge Crossing began the slow, uncomfortable process of recovery and recalibration. The illegal ESA ban was formally rescinded, replaced with a new policy drafted under the careful guidance of the chastened HOA attorney, fully compliant with FHA requirements. Residents with documented emotional support animals, like Mark Jensen and Miss Smith's daughter, could finally live without the constant fear of harassment, fines, or the threat of losing their essential companions. The HOA, under new, far more cautious leadership and grappling with hefty legal bills and federal fines, operated with a newfound, grudging respect for the supremacy of federal law. The mandatory FHA training, when conducted, proved eye-opening for many board members and residents who attended, fostering a deeper understanding of disability rights and reasonable accommodations. Patricia Sterling became a pariah within the community she had once ruled with an iron fist, facing public disgrace, the crushing weight of the personal financial judgment against her, and effectively ostracized by neighbors who now openly blamed her for the community's financial woes. Her life in Cedar Ridge became untenable. The perfect house she had lorded over now felt like a gilded prison. The silence that greeted her when she ventured outside was no longer tranquil, it was condemning. Within a few short months, A discreet for sale sign appeared on her flawlessly manicured lawn. Judge Arthur Pendleton continued his quiet life in Cedar Ridge. His daily walks with Winston resumed their peaceful rhythm, now uninterrupted by hostile confrontations or judgmental glares. He became a figure of quiet respect in the neighborhood, occasionally receiving murmured words of gratitude from residents like Mark Jensen or Miss Smith, people who had felt voiceless and powerless against Patricia's regime. He sought no accolades, content simply to have defended his rights and, by extension, theirs. Sitting on his back porch, one cool evening, the scent of honeysuckle in the air, Winston resting his graying head peacefully on his knee. The judge watched the fireflies begin to flicker in the twilight. He reflected on the unexpected, tumultuous turn his retirement had taken. Justice, she mused, stroking Winston's soft fur, wasn't merely an abstract legal concept confined to dusty law books and imposing courtrooms. It was a living, breathing principle, essential for dignity and well-being. A principle that sometimes required steadfast defense, even on the quiet, tree-lined streets of a suburban enclave. The peace of Cedar Ridge felt different now. It felt more genuine, less brittle. It wasn't a peace imposed by arbitrary rules and enforced conformity, but a deeper quiet, earned through the difficult assertion of fundamental rights and the quiet, enduring triumph of law and reason over prejudice and arrogance. Winston sighed contentedly, shifted his weight, and looked up at the judge, his tail giving a slow, gentle thump-thump against the porch floor. The quiet sounds of a neighborhood breathing easier settled around them.